Okay, that's running. And now back to the webinar. Okay, hello everybody. This is Score Cleveland on a snowy Thursday afternoon, and we're going to be talking about some legal issues with Michael Steele. He'll introduce himself after a brief presentation from me about Score. Okay, Michael, can you see my screen?
I cannot.
You cannot see my screen. Hang on a second. Let me try this. Share it. Okay, let's try this again.
Yeah.
All right, you see it now?
Yes.
Okay, good. I don't want to talk and not be sharing my screen. All right. So this is a brief commercial about SCORE. Just going to tell you a little bit about the organization that is bringing you today's presentation. SCORE's mission is to foster vibrant small business communities through mentoring and education. We support people who are small business owners. As you know, small businesses drive the national economy through job creation and wealth building. And volunteers at SCORE freely give their time, knowledge, and energy to help others. SCORE is the largest network of free volunteer small business mentors in the nation. You might be interested to know there are more than 10,000 SCORE mentors nationwide, and about 90 of them are here in the greater 7-county Northeast Ohio community. No matter what stage your business is in, SCORE has a mentor for you, and you can easily request a mentor by going to our website, score.org. Don't just put in SCORE or you'll get baseball statistics. You have to say score.org. Okay, we support everyone. Anyone who comes to us gets a mentor. We make no distinctions. This is our website, and this will help you recognize you're at the right place when you say score.org. Our services are free because our work is supported by the U.S. Small Business Administration, and we also have sponsors in the greater Cleveland area. All of our services are delivered at no charge. These are some of our sponsors. And please support our sponsors when you can. And this is a QR code which allows you to go to score.org. If your phone is free, hopefully you're looking at this on a tablet or a laptop, just point your phone at this QR code. It will give you the link to score.org, and you'll be off to the races. And I'll give you just a minute to do that. Okay, with that, I'm going to stop sharing, and I'm going to turn it back to our presenter, who will be off to the races here. I will keep an eye on chat and Q&A, and I'll try and answer some of the routine questions. Yes, you will all get copies of the slides and a link to the presentation when we are done. So I'll probably have to answer that again as we go through it, but we're happy to have you all here.
Okay. Thanks for the introduction here. I'm going to share my screen. We tested this out previously, so hopefully this works. Okay. Is my screen being shared?
Yes.
Perfect. Perfect. So before I get started,
there's a gray bar up at the top there, Michael. I'm not sure what that is.
let's see, gray bar. I think that's the let me, well, might be as good as we're going to do.
Okay. All right. Well, proceed, please.
Yeah. Well, I will follow up on your comments about SCORE and its value just real quick. It's one of those things that I definitely believe in, mainly because for all the volunteer work people do. I see a lot of volunteer work where, you really only help the person while you're right there. And the work you get to do with SCORE, you ultimately can help people build their businesses and their careers. And that can really move, really help people out in long term and to really make a difference. So I believe wholeheartedly in SCORE's mission. And that's why I am a subject matter expert, and I'm here to talk about intellectual property types and their infringement. Um, so I'll have a brief introduction of myself. We'll talk about the major four types of IP, and I'll try to go through examples for each one. I found that talking about examples of infringement of each one is probably the best way for people to understand it. And we'll have some time for some questions. Um, as mentioned, I'm Mike Steele. You can read, so I won't go through all of that. But I have been a patent attorney for 20 years, and I have worked at the same law firm in that time, and I have drafted or prosecuted several thousand patent applications. So I know the system pretty well. So the first thing I'd like to say is, why do you need IP? Why does it even matter? And there was a movie when I was a kid called The Princess Bride, and there was a great line in it that discussed the value of IP, probably unintentionally so, where Carrie Yule's character Wesley uh, was pretending to be this Dread Pirate Roberts because no one would surrender to the Dread Pirate Wesley. Well, that was effectively because he had transferred the IP rights from the Dread Pirate Roberts to himself and now was using their brand. And if they apparently had a flag, he's wearing a uniform. All of these things, the names of the ships, they were all intended to instill fear and to make a much less resistance for people that were being looted on the high seas. Whereas if he was just the Dread Pirate Wesley, he would have a lot harder time establishing his brand. So that's the fundamental reason that we have it, is so that you can have an identity of your company, and it can prevent others from using your association without your permission. So, what are the four major types of intellectual property? We have trademarks, that goes to like logos, and service marks, sayings, uh, you know, for the names of the companies. Um, Copyrights are original works, so they cover things like um, recordings of performances, books, presentations, anything that is some sort of actual work that's recorded. Um, Trade secrets, kind of self-explanatory. How to make or use something, then and you just don't disseminate to the public. And then patents, which is my specialty, and which is basically a document you file with the government that shows how to make and use something, and in exchange you get to exclude others from making and using it for about 20 years from the time that you file the application. And we'll get to each one of those here. So we'll start with trademarks because they're probably the most common that you're going to run into. But before we do, uh, you probably have seen all of these different symbols on products over the years. And a lot of times people just don't know what they mean. So I'll just run through them real quick. Uh, the TM, and it's almost always as a superscript TM on something. That means an unregistered trademark, what they call a common law trademark. Circle R is the same thing, except it means it is a registered trademark. SM is a service mark. So, when you're talking about like a priority service or priority mail, for instance, that would be an example of a service provided by the post office, which would be a separate trademark. Trademarks and service marks are really two sides of the same coin. They're effectively referring to the same thing, just a little different language. The circle C, it means a copyrighted work. So like a book or something like that will have that, the circle C, or you'll see it on broadcasts on TV. The circle P is an audio recording, like a song that is now like on a medium like a record or a CD, and so you're emphasizing you record it. The copyright is on the audio of the medium. And then the circle U, I saw this on an A1 bottle, and it was a symbol I'd never seen. And it turned out, so I looked it up and it turned out that's actually the symbol for kosher. So if you see the circle U, it's not intellectual property, but it is a certification of kosher. It was just in the same spot that I would normally expect an IP symbol to be. So there's your learning moment for the day. When you see those symbols, you'll know what they mean from now on. So going back to trademarks, trademarks cover your slogans, logos, and trade dress. And the strength of a trademark is from the use of the mark, not from the filing. So whether you have a common law trademark or a federally registered trademark, um, the real value in them is how renowned your product and your brand are. Um, the trademarks provide a legal recourse to distinguish your product or service. It establishes your goodwill to customers and is a great communication tool to your customers when you see a consistent message, anytime that like we have all these famous trademarks. When you see that bullseye logo for Target, that particular brand is at play there. So it's just helps communicate things to the customers. One of the most important things to understand when it comes to trademarks is that they're there to protect the consumers, not the companies. I once had a client that wanted to get a trademark on Service for America. He explained to me, he says, Teach for America. Well, this is Service for America, where it was like doing something similar where we had to volunteer to help certain people for some amount of time. And I was like, yeah, you're not going to be able to get a trademark on that because by your very name of the company, you're trying to loosely affiliate yourself with Teach for America, and you have no connection to them whatsoever. Like, in that situation, it's not fair to the customers to think that, you might have a connection with them. Teach for America, they could come up with their own, brand. If they wanted to, but they haven't, and so that's the difference. And obviously, the client went a totally different direction, so that was heated advice. But yeah, that's the issue. You don't want to create a false affiliation with a company that you don't have an actual license to operate with. So one of the biggest questions for SCORE members is, do I need to register my trademark? And the short answer is you will always need to register your trademark eventually. But when you're starting out and you're really low on cash, you can get away with a common use or a common law trademark where you put the superscript TM on your products and your logos instead of the circle R. You lose the advantage of notoriety, like basically constructive notice across the whole country. The other If you ever try to assert your trademark, it's easier to contest. But on the other hand, it's free. So sometimes the common law trademark can get you by when you can completely control the use of the trademark and your company's kind of small. But when your company gets to the point where you might be licensing the trademark, and thing I've seen in SCORE a lot is people are creating, businesses that are doing training and they might be certifying somebody else. And in that situation, you're allowing somebody else to use your trademark. In those type of situations, you definitely want to get a registered trademark, contact a patent or trademark attorney, and get the trademark registered because other people now are going to be trying to claim ownership of that. So you definitely want, to have that covered. But when you're first starting out and you don't have the funds for a federal registration, you can definitely get IP rights just by using the superscript TM. So that's a really nice feature that we have in trademark law. So, what is the standard for trademark infringement? And this is the substantial likelihood of confusion, the likelihood of injury to a business reputation, of dilution without of the distinctive quality of a mark or trade name. Basically, as I was alluding to earlier, it's when you're trying to implying that you're affiliated with a company that you're not. That's always a problem. You need to either contact the company um, and uh, proceed with a license, perhaps, or you need to go in a different direction. Otherwise, you might be liable for trademark infringement. A real world example of trademark infringement that came up in the 80s was Lexus Lexus of LexisNexis versus Lexus the car company, which was the subsidiary of Toyota. Um, and Lexus of LexisNexis was, started in the 1960s, I believe, and they sued Toyota for trademark infringement. And this was a very interesting case because the names of the companies are pronounced almost identically, and there's only one letter difference. So the court looked at the factors that weighed for um, infringement, and they had the similarity of the marks, the similarity of the products covered by the marks, the sophistication of the customers, the predatory intent, the renown of the senior mark, and the renown of the junior mark. In this case, number one, there was no similarity in products. Any attorney can tell you LexisNexis is a database of case law, and Lexus is a car, so there's not any confusion on the products that are being used. But this one, the court really leaned on the sophistication of the customers, of the consumers, particularly of Lexus. They said that this is almost exclusively used by attorneys. They would understand that these are two different companies, and there's a very low chance of confusion between these two companies. So that's how the court ruled in there. Since then, the companies have reconciled, and actually Toyota and Lexus Nexus together ran a promotion of Win a Lexus on Lexus, about 10 years later. So no ill will, but that was a very interesting case because the two names of the company sounded so similar. So here's another case. It's what they call a trade dress. So trade dress is when your products, your restaurant, like a tool company or something like that, all has the same look and feel. Our local company in Strongsville Woodpeckers, any woodworkers out there would know that they have a very distinctive look to all of their tools. And so if you have another company that is making a similar looking tool, they might infringe just on the trade dress. There was a case of two pesos tacos versus Taco Cabana Taco Cabana was in Texas back in the 90s. And effectively what two pesos taco was, a disgruntled franchisee that started his own company and didn't change a whole lot in the restaurants. And if anybody's been to Taco Cabana, you'll know that kind of their shtick is that they use outside furniture indoors because they actually started as a taco stand. There was an outdoor one, so they just moved everything inside. And Two Pesos Taco was basically doing the same thing. And according to the court, effectively the two restaurants looked very, very similar. And it said, they leaned on the fact that a business owner that copies a trade dress may be seen as falsely claiming that his products may, for some reason, be thought of as originating from the plaintiff. Basically, you're creating that false affiliation, and then so that's just not fair to consumers for that. So most of you probably aren't familiar with this case, but anybody in Northeast Ohio or whatever that likes tacos, interestingly enough, another taco case is probably much more familiar with Barrio Taco versus effectively the company we all know as Condado Tacos. And the background here was that Condado Tacos was started by a co-founder of Barrio Tacos. They had a falling out, and originally they had an agreement not to compete in an area. I don't know all the details of their contracts, But when Barrio tried to assert a trade dress claim against Condado Taco, the court basically looked at it and said Barrio didn't have enough to be trade dress. They said that Barrio isn't a distinctive name. The Day of the Dead decorations they used were very common in Mexican restaurants. They said, Barrio uses black and white color scheme, while Condado uses pastel colors, different signage. And the remaining similarities, even though they operate the same type of restaurant of ordering forms and they use mason jars. They said these are not features that are unique to Barrio. So Barrio failed to establish the ownership of the trade dress. Therefore, there could not be any trade dress infringement. And I found this case very interesting because the very first time I went to a Barrio taco knowing nothing about it, my first thought was this seemed, or I'm sorry, we went to a Condado's. I said, this really looks like Barrio. I knew there had to be some sort of connection, but you could tell that they weren't the same restaurant. If you go into a Condado, there's not any confusion that you're at uh, a Barrio. They look very similar, but you can make the same argument about like a lot of fast food restaurants. Um, but there was enough distinction is really, I think, what this case came down to, reading between the lines. So, one of the issues with trademarks is genericized trademarks. Now, I promise you, this is a problem every single one of you wish you had. This is the ultimate sign of success. And it comes from when your product is so famous and has a trademark that people don't know the actual name of the underlying product and they only know it by the trade name. And one of the most famous cases of that was King Sealy Thermos Company, and they lost their trademark for the name Thermos because I think that they alleged that the actual product was called a vacuum bottle, but they couldn't find hardly any reference that they weren't using where anyone called it a vacuum bottle, and effectively the court says you can't own the name of this product. You can call it an original thermos, and you can put the circle R, capital T, whenever you use the product, and show that it's a registered trademark. And the other company has to use lower T, and they can never have a trademark associated with it. They just go, like they could have an Aladdin thermos, but they can't emphasize that they own the name thermos. Um, Effectively, anybody was allowed to use it, and because it referred to the product. So here's a list of genericized trademarks. Again, problems that everybody wishes they had. You got some words that I had no idea were originally trademarked from, whether it's dry ice, trampoline, escalator, flip phone, kerosene, laundromat. And just recently, we had deregistration of Taco Tuesday. I think it was Del Taco, I believe, originally owned that trademark. One that I'm still convinced will eventually become genericized is a Blizzard because almost everybody that goes to soft serve ice cream places um, that will serve some sort of mixed in soft serve, and they'll call it something like the McFlurry, the whiteout. They're basically calling it a Blizzard with a different name. I remember talking to somebody that said, "Well, that isn't a concrete mixer the more generic name?" And I was like, "Well, that's for frozen custard." And as an ice cream connoisseur, you know, I would never confuse frozen custard for ice cream. So in my mind, there's no question that those are two totally different products. But at some point, I won't be surprised if Dairy Queen loses their trademark on Blizzard just because that's what everybody calls that product, right? So the next major area of IP is copyrights. They cover original works, computer code, advertisements, films, podcasts, and artistic works. Basically, something that you can have a physical storage medium that could be reproduced, and you can now show the same performance or the same work at a different time. Um, You get a copyright, interestingly, by just making it. So when the work is created, you make it, you get the copyright, and you don't have to register them. You have to register them if you want to assert them, if you want to sue somebody um, for them, but you can't be but you're not required to actually register them until then. A lot of people do because it's just more convenient. If you have a photographer or something, they have different systems in place to help people record like massive volumes of works. Um, but for a lot of people, you just need to make good record of when you created the copyright, time stamping of your pictures and things like that, that can show that you own it. There is a thing called the fair use doctrine. The fair use doctrine allows you to have a non-commercial use of copyrighted material that does not diminish the copyright owner's ability to make money from it. And this is a good example of us, for instance, referring to football games. When we talk about football games, or even you write about football games on blogs or anything else, you're not diminishing the NFL's ability to make money on their product. You're simply referencing the Cleveland Browns, for instance. As long as you're not, using their logo in an unlicensed manner, and like we're selling, T-shirts or something that have their logo on it, but you're allowed to actually, use the names of the players, the names of the teams, and the coaches, and things like that. There's another exception related to parody. There's broad discretion that you're allowed to infringe on copyrighted materials if you can show that it is a parody, because a parody is considered part of protected free speech. And if it's clear that you're making fun of something, you know that goes a long way with the court. But it has to be clear, and we'll get to that example in a second. Um, as I mentioned here earlier, you don't have to register, but you need to register if you're going to sue. And another thing that I get a lot of questions of: what about employee created works? Works created by an employee within scope of their employment are considered to have been authored by the employer for copyright purposes. Understand, this is very different than a work for hire when you contract with someone. If you hire a photographer to take pictures, for instance, the photographer will typically still own the copyright to the works. Whereas if you're hired by the photographer to help out, taking some side pictures or whatever, then that photographer would own them because they're your employee. It's the difference between a contracted work and employer-employee relationship. It's a very important issue for the SCORE members, because there's a lot of times where you might be having employees, and there's a lot of times when you might be contracting work out. So it's good to have those discussions with them, who owns the work at the time, that the copyright is made, at the time the pictures are taken or the performance happens. So let's go through a couple of examples of copyright infringement. So they look at the uniqueness, the intricacy, the complexity, and the similar sections, the idiosyncratic elements that are repeated throughout both works, the appearance of errors or mistakes in both works, fictitious entries. There's even a movie called Paper Towns that actually referenced this, where you basically had, in the old days when cartography was still a job people had, and they would make a lot of maps. Cartographers would insert fake names of cities in their maps, and then when a competitor might copy the map, if they put that same fake name in, then it's pretty evident that the only way they've known about that fake town is through the copying of the map. So it's sort of a trap that they would sell or set for them for to detect infringement. And then, of course, there's the obvious attempts to give the appearance of dissimilarity. And the examples here are just from, movies we have, or television. We have the Buy More from was the show Chuck, and then McDowell's from Coming to America. In both of those, were just clear ripoffs of the other company. But in both instances, they were working with permission of McDonald's and Best Buy. However, they didn't really have to get that permission because both of those would have absolutely be seen as a parody, and because they weren't real stores, they weren't real competitors. They were just fictitious entities. So here's an example of actual copyright infringement, um, where we had the old New Yorker picture from the 1970s, which is this like the New Yorker's view of the world, where the New Yorker shows this, highly detailed um, version of uh, this highly detailed version of Ninth Avenue, 10th Avenue, and then now you get to the Hudson River and everything gets real abstract. You barely, there's the Pacific Ocean. It's just like everything in their life comes down to what happens in New York. Well, somewhere roughly 9 years later, give or take, this Moscow on the Hudson movie came out, and they had clearly copied the same, look and feel of this of the original New Yorker magazine article. And in this particular instance, the court said, uh, the one was clearly a derivative work of the other. You couldn't argue that they were completely dissimilar. And then actually, uh, Columbia Pictures tried to argue, well, this was in fact uh, a parody. So this was a parody. And they said, well, it is a parody, but it's not a parody of the original work. It's a parody of how New Yorkers see the world. And in this particular instance, they said, well, okay, um, you know, you're not making a parody of the work. You're just making a parody of the same message. And so you didn't really invent the parody, and so they did find infringement. Um, there was another case that most of you are too young to remember. I'm old enough and nerdy enough to remember this situation. Um, Almost all of you know about zip files, but a lot of you probably don't know about the background of them. They were originally PK-Zip. PK is still a company, and PK-Zip was started by Phil Katz. And he actually worked for a company called C, and they made the .arc compression format. And Phil Katz starts his own company, and he made PK-Arc. And when C sued for copyright infringement, they looked at the code and they said the code was almost identical, and they had some of the same comments, including misspellings in both codes. So they deemed it to be a derivative work. Now this is a good case where so they settle, and a good case where the copyright system actually resulted in something better. PKWare changed their protocol to the .zip file, and this was more efficient than the .arc file anyway. And this is still this a later derivative that we use today. So that's how zip files worked, and it was, originally came from a copyright infringement case. So the next slide for explaining is going to talk about fair use of computer code, and it's important to understand what an API is for that. So I'm going to spend a couple of minutes just talking about that. Anyone that is a computer programmer can tell you an API is basically a series of function calls that you can use another computer program to interface with your backend software. So this is very common for web interfaces. So you have one application that's running a web interface, and then the backend application might be a database. And in that sense, you basically are using the database's API to manipulate the database itself. But it creates a user interface that is, much more friendly than a user interface of the database would typically be. The analogy sometimes is, given as a user would be the program, and the waiter would be the API, and the waiter then deals with the kitchen staff to make sure the order's right, and then brings back the order to the people. So As a simple example of an API call, we won't get into the code too much. This is a way that you can write a simple program to send a text message, an SMS message through through another code, and this is basically Twilio. Twilio allows you to send these text messages, and so you can send text messages right through a computer program and not necessarily have to use your phone to do it. So why was that important? Because in Google v. Oracle in 2021. The background of this case goes on quite a while. And when Java was originally owned by Sun Microsystems, um, they developed um, they developed Java, and then Google wanted to use Java for Android. Well, Java was bought along with pretty much all of Sun Microsystems by Oracle. Um, so that's why it's Google v. Oracle. And after negotiations broke down, what Google did was they used the same API, like the same function calls, but they rewrote all the underlying code to run on their own backend server. So basically, their Android system was compatible with Java, but it wasn't using Java's code. And the the Supreme Court, this went all the way to the Supreme Court, they ruled that um, the amount of code copied, only 4.4% of the material, even though that was an important 0.4%, wasn't enough to be copyright infringement and determined it was fair use. Um, basically, that this allowed Google to rewrite Java completely, effectively taking ownership of Java, at least without a license, and still have their code compatible. In this particular case, the court had the following blurb. It says Google copied those lines not because of their creativity or beauty, or even in a sense because of their purpose. It copied them because the programmers already learned to work with Java, and it would be difficult to attract programmers to Android without them. The reason why I bring this case out is I find this, I don't agree with the Supreme Court, but who am I? So this is the law of the land. This exact statement I completely agree with, but this is why if I personally would have been on the Supreme Court, I would have ruled a different way, because basically this allowed Google to get the benefit that Oracle and Sun Microsystems had spent years, producing material, teaching people how to program in Java, and this allowed, Google basically to take a shortcut and get all that benefit from all those well-known Java programmers without actually paying a license. And that's what I found to be. I mean, their reasoning just led him in a different direction. But I can't disagree with this statement here. I would have ruled differently because of this same statement. And Justice Thomas, Clarence Thomas, made a dissent here, which normally wouldn't mention dissents, but he stated that in his majority, under the majority opinion, it makes it difficult to imagine any circumstance which declaring code would remain protected by copyright. It just basically, this case really made it easy to rewrite code, not copy code, but rewrite code and do the same thing and not be considered infringing. So that's, because before this case, I got questions a lot, and this is not how I expected this case to be decided. So, but there you go. Trade secrets we'll talk about real quick, just because they're sort of self-explanatory. You get your Coke formula, the KFC's original recipe. I like this one because they actually have two different factories that make the original recipe, and then a third factory that mixes them, so nobody has the original, all of the ingredients. And the trade secret lasts forever as long as you can maintain the secret. You have to have an economic value that can't be legitimately obtained, um, and you have to provide reasonable efforts to maintain the secrecy. Now, a trade secret will not protect you from reverse engineering. There's nothing to prevent somebody from taking the kernel's recipe to a lab and trying to dissect all its ingredients. Now, trying to figure out its proportions might be really hard, but you can do that. So that's how trade secrets work. They're very difficult to prove, but if you can prove them, you have a strong case. But they're mainly guided by contract law, probably more than IP law. from my perspective. So. Now, finally, my area, and we won't talk about it too much because most of you probably don't have a patent, and most of you probably don't need one, but I deal with this area a lot. So there's two main types of patents. There's design and utility patents. Design patents operate on how something looks, its aesthetic qualities, and uh, utility is on how they operate. Um, and one of the things that is sort of underrated is the value of design patents because they're a little bit broader than copyright on the same products, um, and they can still provide good value of to prevent infringers. If you see on the right hand side here, we have two different versions of the Simon Says toy, and you can see that when I was a kid, those buttons for Simon Says or Simon, like you actually could push those buttons. Now they're just sensors that can detect a fingerprint to them. In both cases, they have the same look and feel. So both, if somebody had come along and used the touch buttons, the finger, without actually depressing them, they would still infringe on the design patent. But if you had a utility patent that had, those depressible buttons, they probably wouldn't infringe. Um, the most important thing to understand when it comes to infringement is you have the right to exclude others from making and using your product. You do not have the right to make and use your product, and that's doesn't seem like a big distinction, but sometimes you have to infringe on somebody else's product in order to make yours. And there's a famous case in patent law where you had one company invent the diode and one company invent the triode, but you couldn't make the triode without making the diode. And so in that situation, they both companies cross-licensed the diode and the triode to each other, uh, and then they were able to keep everybody else out. So yeah, they had still to compete with each other, but they were able to stop every other electronics company from making either the diode or the triode and gave them both big competitive advantage. So there are those type of situations out there. So it's important to understand right to exclude, not right to make and use. So what is patent infringement? Each patent ends itself with at least one claim. Like typically we'll have between we'll have usually between 10 and 20, but you see all sorts of numbers. I've seen as many as one. I've seen several that had a few hundred. Um, but each one is the same way. Each claim has certain elements, element A, B, and C, as you can see here. And then you have a dependent claim that'll have element D. An infringing device has to have all of the elements of the independent claim. It can have more, but it has to have all of these. So you see an infringing device would have elements A, B, C, and D. It would infringe on claims 1 and 2. But if it had E, F, G, this is irrelevant for infringement. These extra features do not make it not infringe. So a product that only infringed on claim 1 would be A, B, and C, not have D, E, F, and G. So it didn't infringe on claim 1. And a non-infringing device would have only B and C. It would not have A. So even with just this knowledge, if you ever run into a situation where you're trying to decide, is this, are they infringing? Do I have a patent application or a patent? And are they infringing? This is how it works. You have to look at each part and say, is this part there? I've gotten situations where independent inventors contacted me, asked me for advice on situations, and within like 5 minutes, I can look at it and just say, determine if they do infringe is very, very hard, but sometimes it's very clear they don't infringe when I just ask them, like, does this infringing device have this particular element that you're claiming in your claim? Well, no. I'm like that, then you're sunk. And that's all, honestly why the difference between somebody that dabbles in it and tries to draft their own patent application and a patent attorney is going to understand this. Somebody once told me that didn't have it stinks because they got away with the technicality because they didn't have one element, and I'm like, that's like literally saying that the fence, somebody on your neighbor put something in the other side of the fence that you don't like that's your fence defined your property. They just put it on the other side. Like that's what they're allowed to do with their property. And it's literally the same thing with patent infringement. If you don't claim it, if you don't have a claim that covers that embodiment, then they don't infringe. And it's not a technicality, it's the definition of how a patent works. So, as an example, as I mentioned earlier, for woodworkers here,
A key
this,
component of
I'll
every
turn off the
saw-stop
sound
saw,
here.
the patented safety feature, is made possible by
Yeah.
a sophisticated mechanism. But the concept is actually very simple. The blade carries a small
Okay, well, I didn't need the volume here, but
a key component of every saw-stop saw. The patented
that's real
safety
helpful.
feature is made possible.
Let's go to the next slide.
Mechanism. But the
I've never had this happen on this
concept is actually
presentation
very
before.
simple.
Sorry. Okay. The important things to look at for both of those cases from as a woodworker is both of those saws have technology in them that if you touch the blade while it's spinning, the blade will drop below the table. In SawStop's situation, the way it worked was they have an electrical current going through the blade, and when you touch it, the blade drops below the table because it disrupts the electrical current, and that's sensed. And then that blade hits a brake that's beneath the table. Bosch created a similar situation that detected a finger the same way, that disruption electrical current, but they actually used airbag technology that they also had to make a small explosion to force the blade beneath the table, and the blade never hit a brake. And the reason why that's important is look at this particular patent that SawStop owned. Here are their elements: a work surface, a cutting tool, a detection system to detect a dangerous condition, and a reaction system, wherein the reaction is configured to retract the cutting tool below the surface within approximately 14 milliseconds. 14 milliseconds being not enough time to cut your finger off. And they said, and this was an International Trade Commission holding, ITC, and they said Bosch does infringe on this because they didn't specify how the tool was moved beneath the surface or how the blade was stopped. And the reason why that is important is because you can see this other patent that SawStop had, because they had over 100 patents covering the SawStop. They have this element here, a brake configured to engage the blade upon detection of the dangerous condition. And as I mentioned, the Bosch system had no such brake. In fact, the blade would continue to spin underneath the table. That was supposedly an advantage that Bosch had because it wouldn't damage the blade itself when you touched it. It would just push it beneath the table. So Bosch didn't infringe this particular patent. That was the holding from the ITC. What's important, though, from that is they only needed one patent to infringe. If they had, if they showed that they had 100 patents and Bosch infringed one of them, they can block importation of all of the devices from Bosch. They weren't limited to, so you only have one patent that you're infringing, so you only can block a certain percentage or anything like that. It's like, no, you only need to show infringement on one device. And why that's so important is because it shows you the value of having multiple patents on your product. I sometimes tell people having one patent is like being a stamp collector with one stamp. You can put it on the wall and look at it, and it's pretty, but it really isn't going to make you any money. Whereas if you're a stamp collector and you got a big, you have the full series of stamps and things like that, those are the ones that are actually going to have real value over time. So, last word here. This isn't directly about IP, but I get a lot of questions about NDAs, non-disclosure agreements, because they often touch. The NDA is usually about intellectual property. NDA is a contract that defines relationship to intellectual property. It's not a replacement for IP, and it defines a relationship between two parties. My advice general for anyone is don't sign an NDA unless you know why you're signing one, and find out when the NDA expires. Sometimes they expire when a patent is filed, but I've had situations where people wanted me to sign an NDA for no value, no benefit to me whatsoever. I had a company that wanted me to look at some software before I did, they wanted me to sign an NDA. I'm like, well, you're going to pay me, but no, just going to give me the software. I'm like, I don't, nothing in it for me to give you feedback on this, the software that you want to show me. So I'm not signing the NDA. It's no benefit to me. So always just be careful when you even consider signing one, to know what your benefits are and to know what your responsibilities are under the NDA, because sometimes they can be tricky. Um, and problems related to NDAs, contract work, like programmers for hire. Um, the NDA might prevent the disclosure of the work to other clients, but doesn't mean that the contractor has to assign you the patent rights. I've seen many cases where somebody's, well, I had an NDA with this programmer. It's like, yeah, but that doesn't mean that they are going to assign you the patent rights to it. That's a separate issue. And so when you're drafting your contract to like have programming work done to write an app for you or something like that, you need to be very clear on who owns the intellectual property. Who are the inventors and who owns the intellectual property? Two different questions, because you could easily have the situation where the contractors are the inventors of it. You tell them to go invent something, or go do something, and you would be considered an inventor possibly, but then the programmers that actually implement it would also be considered inventors. You'd be co-inventors, and in those scenarios, who then is allowed to file the patent application? Because if you don't have a pre-existing agreement, neither one of you is likely to agree afterwards without exchange of funds of what company gets to own the patent. So that's just something to, be very weary of when you're hiring programmers out there. If you're doing something you think is inventive, have the discussion before they start doing work. If there's a patent eligible subject matter, who owns it? Because if the contractor says they want to own it, you could say, well, okay, I want a discount then for doing the work, because you're gonna be able to sell this work, to other people, so I shouldn't have to pay for all of it. Whereas if you say I own the patent, then the contractor very well might say, well, okay, you're going to own the patent, but we're going to charge, there's an upcharge for that because we thought we would own the patent. So having that negotiation point at the very front, very, very helpful, and avoids a lot of conflicts at the end. So that's what I've got, and I will now stop my share and open it up to some questions. Looked like there were a number of comments, but I was
We've
focused, so I
got a
didn't really get to read them.
boatload of questions here, Michael, and probably more than we're going to be able to answer in this session. Also, Michael, you might want to say something about giving legal advice in webinars so that they know if they want to have something specific for their business to contact you directly.
Okay, yeah, that's something I should have mentioned. So, as a SCORE volunteer, I'm not allowed to even give legal advice, but a lot of to SCORE members. However, most of the stuff that I'm telling you is just general education for things like when I talk about the NDAs, just things that you need to be aware of. If you need a contract or something drafted, contact an attorney. And if you have questions about IP and you want to contact me, I'm available. My email address is michael.steele@scorevolunteer.org. And if it's just an educational question, I can answer it. If you need actual attorney work, I can probably help you find an attorney that can work with you and your company. Okay.
The other thing is when we make a referral, it's just for your information. The SCORE assumes no liability for the referral, entirely your responsibility. What happens once you act on that referral? I had to add that.
Fair enough.
Okay. Okay. I'm going to try and pull off some questions that have really wide scope to everybody. Yes, the recording will be available to all attendees. You will also get a link to it. Okay, now here's one. If you hire someone to make a design for you, do you need a contract stating that the design now belongs entirely to you?
Yes, because because that goes down to what I was talking about, the difference between an employee and hiring a contractor to do the work. In the scope, ideally, the original contract that you have with the person to do the work for you will specify the IP rights, like a photographer, for instance, would transfer the IP rights to you after they do the work or after they make the painting or something like that. If they don't, then they're still owner of the IP rights, not necessarily the original product. You still would be allowed to have the product that they made, but you wouldn't be able to reproduce it and things like that and sell it.
I think this is a licensing question, but you'll need to dig into it. How do you protect your IP when you are involved with making your product available for private label distribution?
Could you repeat that? It was
How do you protect
complicated.
your IP if you are licensing your product for private label uh, uh, distribution? Uh,
Okay, so one of the issues you run into a lot is if you have a private label distribution, and that can be a lot of different ways. You can certainly use trademark law to stop somebody else from using your logo. But what's very common in Chinese manufacturing, because I've seen this, is if you send them a set of molds for injection molding, um, and you hire a certain number of hours, that's less than 24 hours a day of product, they will sell the product out of those molds to somebody else, to a competitor. And so in those cases, you really need to rely on patent law to stop the importation of the infringing product. There's a whole a modified court system that Amazon has set up for that. This is a good situation for when you have a non-functional, part that a design patent would cover. So you get the design patent on even part of the whole product. And if they were using the same molds, then it's really easy to show that they, would be using, they'd be infringing that product. So that's the common way that is handled to stop another company using their product, their company name, and pretending that they invented that product or that they own it.
Here's a question from a contractor's perspective. You mentioned you have to be careful about your interests in signing an NDA. What are some red flags to look out for before signing an NDA?
The biggest red flag is to somebody asks you to sign it and you don't know, like, you just sign it because you think it's just boilerplate. You just think, like, okay, well, it's just what you have to do business, and it's like you don't even know what you're signing. And the real concern there is a lot of times the people handing you the NDA don't know it either. It's sort of like, you get the credit card agreement or software agreement for using it. It's 10 pages long. Who's reading that? Probably no one. And sometimes you have situations where people just act like NDAs are sort of that type of contract. They just sign them and don't pay any attention to them. And that's definitely not the case. You need to at least know, why you're signing it, what benefit you're getting, and what responsibilities that you're giving up or that you have to do to maintain the NDA, and knowing when it expires. That's all of those are. And if you can't answer those questions, then you probably shouldn't sign the NDA. I mean, otherwise, you don't know what you're signing or what the consequences are.
Here's a kind of an interesting fair use question. I'm going to interpret a little bit from what the person wrote. If you're making a video with YouTube and you use images that are available for free on the internet, is that fair use? And are you still okay to make money from that copyright, from that video, even though you use the free images from another source?
That's gonna, like, honestly, that whole thing is probably too specific to answer without actually seeing the situation.
Okay.
In general, you will find free use, like there are pictures out there that say that you can use anything for these, sure. But if you copy them and you have less than that, and then you use them on a video, then I mean, it might be unlikely, but you are the possibility that the copyright owner could assert that against you. It's just, but you have to look. It's very going to be very fact specific to your situation, and kind of more outside the scope of this talk.
Okay, here's a question. If you don't use an NDA and you want to just show someone, perhaps a potential investor, your intellectual property, how do you protect it and prevent that investor from running off with it?
Well, it depends on the investor, and one of the things you can do is file a provisional patent application, on a product before you show it to investors. In the United States, this is the only country that does this. that or only significant country that does this, I should say, you can actually show people your patent, your product for and sell it for up to 1 year before you file a patent application. Now, if you sell it to anyone before that, you won't be able to get a patent in any other country that you'd want other than the United States. You're trying
Michael,
to
Michael, you're freezing up. You're
okay, hold on a second. Let me, yeah, it says internet unstable.
Okay, we are
Okay.
out of time at this point. It is 1 o'clock, and there's another session that comes behind us, so we have to get off of the Zoom for the way we manage our account. So we're going to have
Okay.
to wrap this up. Just want to remind everybody that you will now. You also can find Michael Steele's profile at score.org. What you can contact him through that way, and you can also request him as a mentor if you have a desire to use his particular capabilities. So don't forget that that's also a way to reach out to him. Thank you all very much for attending today's session, and now I'm going to close it.